Hi guys, welcome back to my channel, The Short Tips. Please remember to like my videos, subscribe to my channel and hit that notification button below. Today, I'll be talking about the contract legal checklist. Not just for business owners, entrepreneurs or startups. This is obtainable to everybody. If you're going to get into an agreement with somebody, into a contract, into whatever kind of business that involves financial benefits, please make sure to drop a contract or have the lawyer do so. So today, I'll be talking about the checklist, what clauses that need to form part of your contract to make it legally binding to both parties.
Call it love and devotion. Call it a mom's adoration. Foundation, a special bond of creation. For all the single moms out there going through frustration. Clean Bandit, China Ball, and Marie thing make them air.
She works the nights by the water. She's gone astray, so far away from us. She tells him, ooh, love, no one's ever gonna hurt you, love. I'm gonna give you all of my love. Nobody matters like.
What is a contract checklist? Contract checklist is a step-by-step list that helps you, form parts of your contract before actually finalizing it. This helps reduce miscommunication, setbacks, strife between both parties. It makes sure that both parties to the contract are on the same page at every point in time. So for lawyers, we call them clauses. Those legal clauses that helps bind both parties, not just words. So those things that actually binds both parties. So today we're going to look at the different checklists that you need or clauses that you need that makes your contract watertight. Why is a contract checklist important? A contract checklist is important whereby there's a contract dispute or there's a dispute that arises whereby both parties or parties to an agreement to a contract, are in breach of certain clauses in that contract. So if your checklist is not in place, if you omit certain clauses and your contract is not airtight, then you might not be able to have a redress in court. You might not, for example, if you miss out the arbitration clause, when there's a problem, that means you can't resort to arbitration or mediation before taking the issue to court. If you miss out maybe a payment due date, like you say, okay, after payment has been made, I would require 7 days to make sure that the other party receives their money. If those things like date, time, they are not expressly spelled out in your contract, then it becomes a problem, like duration or what can, make the contract to be terminated, whether force of nature, whether negligence by a party, who bears liability and risk, who pays for certain things. All those things form the checklist of a contract. So it's really important because usually when more than one person is involved in a contract or in a business that involves money is a very sensitive issue in business. Whenever people come together to run a business or handle a project that involves money, it's important to have a watertight contract agreement that binds everybody involved, because usually disputes arise. Most times people are not on the same page. Most times you might think that, oh, I actually said this thing, there was a verbal agreement, actually said something, I'm sure this person understood while we had this meeting. Most times people don't even understand. You might be saying one thing and some other person is hearing and understanding another thing. So there are usually misinterpretations and miscommunications when verbal agreements are made. It's important to put them in writing, to have your checklist, to have a watertight contract and agreement that can bind both parties. It protects you, it protects the other party. It's fair. There must be fair terms at all times. Do you understand? And that's why I always tell people that always have a lawyer drop a contract for you. And then whoever the other party that is going to read the contract or that has to sign the contract should also have their own lawyer go through the contract, review that contract. And if they have issues with certain clauses in that contract, or they feel that certain clauses has been omitted, or they feel that the contract is not fair or doesn't have fair terms and doesn't favor them somewhat, then they should have both lawyers sit down and discuss it and then come up with a contract that is acceptable and fair to both parties at all times. So I'm going to discuss the different clauses. I might not exhaust all of them today because of time, but I'll discuss key components of those contracts to make sure that Whenever you have to draft a contract, or you have to review a contract by yourself without actually involving a lawyer, it's very important to use a lawyer because of the stamps. Now with the new MBA rules and everything, court rules. But then for you to be able to review before you involve a lawyer, you need to like have a checklist to check, like, okay, this is there, the time, the dates, the termination clauses, the arbitration clauses, who has jurisdiction over what, when there's a dispute. It's important to have all those things in place. What should form part of a contract checklist? So first, parties involved, super important. You need to know if it's a personal contract agreement, so it should be the names of the parties involved. So not just Charles, or maybe but Charles Johnson. So the name and the surname, because if you just use Charles can be anybody, right? So if it's Charles Johnson, then it has to be Charles Johnson's home address that should be part of that contract. But then if it has to do with a corporate body, a business name, then it has to be the name of the business and the official address of that business. So it forms part of the component of the contract, a checklist. You have to make sure that the names are properly spelled, the address is there, because you need to know the parties involved in the contract and the parties that are binding when, in that contract. Then secondly, the date is important. You need to know the start date of that contract. When does the contract start? When does the contract begin? When does the contract end? Duration of contract is important. Thirdly, now that I've talked about duration, so I should also talk about termination, because when something starts, there must always be an end point. So you need to decide if you want the contract to be renewable. Like you say, okay, I want this contract to be in operation for 2 years, and then after 2 years we can renew it based on certain terms, and then maybe based on certain terms and agreement between both parties, depending on what the project is all about. But in a situation where the contract does not even have an end date or does not have a renewable clause, right? And then the certain clauses has to be in place, like termination clause, to determine what might be in breach to end that contract. So maybe negligent for both parties, or maybe one party that is supposed to pay the other party doesn't pay the other party, or they're not carrying out, there's a delay, they're causing delay on the project. So all these things, form part of the termination clause. Like, what would I do in this contract to annoy the other person, or that I'm not, we've set out certain obligations within this contract. I'm not meeting up to my obligations within this contract, or the other party is not meeting up their obligation within this contract that will cause a termination to happen, right? So there must also be a force majeure clause, whereby there's certain delays or negligence or things that happen within a contract that is not caused by either party. It's just by force of nature. So for example, if you're in a business of road construction and you're trying to deliver during the rainy season, there will definitely be an issue, a bit of delay during heavy rain downpour, because contractors and people will not be able to work. So it will cause delay, and such delay, because of the time of the year, you can't hold any party to be at breach or to be in breach of the contract. So having that clause is also important. Then we'll have like the valuable consideration, which most people will call the financial consideration, when money is involved in a contract, a project, spelling out what percentage both parties have, profits to be shared, when those profits will be shared, before, whether it will be upfront or after contract has been executed, whether profits will be shared after, whether it's a net profit that will be shared, whether profits will be shared after all expenses has been made. All these things must be spelled out in the contract, because trust me, as a lawyer, like I've seen so many contracts and projects go sideways, right? Because money was not, how money will be shared and how money will be used, it was not expressly spelled out. So this is really huge, in terms of a checklist of a contract. Then we also have the arbitration clause. Usually, it's important to try to solve your dispute. Disputes must always arise, because you're dealing with more than one person. You're dealing with, another person that thinks in a different way, lives in a different way, perceives things and businesses in a different way. So external factors might affect the thinking or the thought process of both parties or all the parties involved. So usually disputes are unavoidable in businesses, in partnerships, in collaborations. So it's important to always include the clause, that the arbitration clause, that when there's a problem, instead of just going straight to court to get a redress, why don't you sit down and try to mediate, negotiate, and settle issues amongst ourselves? Doing that also brings for healthy relationship moving forward, healthy business relationship moving forward. Okay, there are so many other clauses involved in a contract or agreement, but like I said, due to time constraints, I might not be able to spell out everything. But then, what actually causes parties to actually have a bad contract when you don't use the lawyer? Most times, people feel that they can do it by themselves. But when it comes to contracts and agreements, I always advise people to use a lawyer. Both parties or all the parties involved should get a lawyer to protect themselves, to make sure that the contract actually has fair terms and is actually conveying their emotions, what they feel, what they think should be, should be fair to them within that contract. If you have any questions as regards this topic or previously discussed topics on my channel, feel free to drop me a comment, send me an email, or book for your free consultation. Till I come your way next time with much more interesting legal and business tips, please remember to like my video, subscribe to my channel, and hit the notification button below.